Okay, so hi everyone, and thank you all for being here tonight. I'd like to welcome our guest speaker, Angela Odensky. She is a graduate of the University of Houston Law Center and a certified elder law attorney. A certification in elder law means that she has an in-depth understanding of the laws and situations that impact adults like us who are approaching retirement or older. Her services include wills and trusts, powers of attorney, medical powers of attorney, physician's directive, and all the other forms that are necessary, and some that you've never heard of either. The more in her services, though, from my perspective, includes wise counsel and the ability to ask all the right questions that regular attorneys who aren't dealing with elder laws or older adults never think to ask. So anyway, we've given Angela a list of questions that were compiled by Gail Neeson. Thank you, Gail, to address for us tonight. If you have additional questions, please put them in the chat box. I'll be breaking in to have Angela address them as we go along. So everyone, please turn off your videos and welcome Angela.
Thank you, Julie. I'm so happy to be here. I did one of these sessions at Gail's house a few weeks ago. And so this will be sort of my second outing with the soloist group. I want to preface everything by saying that I cannot offer legal advice. I can give general information about the questions that you are asking, but without attorney-client relationship and more in-depth knowledge of your specific situations, I can't necessarily address each of your individual specific concerns outside of a general, just sort of generally answering. So some of my answers might start with, well, it depends, right? And then kind of go through how it depends. And then some of my answers might simply be, you'll have to contact my office or contact another elder law attorney. So just kind of be aware of that. When you're asking questions, we're looking for more generalized information that is appropriate for the entire group as opposed to specific to yourself, because I have to be very careful about answering those just from ethical perspective. I don't want to answer something where I didn't have all the information and give you bad advice, right? Okay. So my name is Angela Odensky, and I am a certified elder law attorney in Bel Air. I think what Julie said is exactly right. Being a certified elder law attorney and working in elder law means that I have a different approach, different perspective to your estate planning documents and how people approach their aging process. So one of the first questions was, is there a concise or just like one of the questions is, what's the difference between like elder law and estate planning? And estate planning attorneys are generally very concerned with your legacy. Elder law attorneys are generally going to be very concerned with your aging, ensuring there are people in place to make decisions and making sure that your aging is as smooth as possible. So first up, is there a concise term recognized by elder law attorneys that describes our solo demographic? Yes, and y'all don't like it. It's called elder orphans. That is a common term amongst elder law attorneys, that when we say, I have a client who's an elder orphan, everyone knows what that means. And generally speaking, what that means is it means somebody who does not have a lot of people that they can rely on. Maybe they don't have children, or their children are estranged, they don't have a spouse, they don't have nieces, nephews, etc. They're not surrounded by a bunch of obvious choices to manage their affairs. And so we use that term very specifically as a definition, as a way of defining a population of people who have very specific needs that we sometimes have to struggle to find resources for. What happens to us if we are incapacitated or die before we have our next of kin designated? So if you become, so that's two separate questions, right? So if you die and you don't have beneficiary designations, you don't have a will, you don't have an estate plan, everything's just sort of left in accounts with no indication of where it's going to go, there is a Texas statute that says where it goes. It's called the legal term for it is intestate, when a person dies intestate, that means that they have died without a will. Or without any kind of estate plan in place. If you have beneficiary designations on your retirement accounts, life insurance, et cetera, if you have pay on death designations on bank accounts, even if you don't have a will, they pass to somebody. So that's helpful. But if you don't have anything in place, then we call that intestate. And there is an intestate succession chart where the state of Texas says this is who gets your stuff, right? It's listed out for you. And it's quite detailed. Texas is very intent on making sure somebody along the line gets something somewhere. If we have to go up to like grandparents level and then over, parents level and then over, if you don't have siblings, etc. So we have a very robust intestate statute. You may not know who they are, but they'll get your stuff if you don't like put it down otherwise. Who gets contacted if we have no identification on us and no designated next of kin or emergency contact? Honestly, if you don't have any way of identifying yourself and you don't have HIPAA authorization, you don't have medical power of attorney, you don't have a designation for your agent under a durable power of attorney, if none of those documents exist and you're literally unable to communicate, there's no one that will be contacted because no one knows how. Now, there are some, don't get me wrong, the ethics departments at especially the local hospitals are phenomenal, and they are absolutely like, they want to find somebody. I sat in on a council meeting at Memorial Hermann with the ethics department once. A friend of mine had worked in the ethics department, allowed me to sit in to see sort of what the issues and everything were. And one of those social workers like had an address for somebody, and so went and banged on neighbors' doors until they found a clergyman who knew the person and who could find somebody to come in and help. You are lucky. You would be lucky to get somebody at a hospital who is willing to do that. But generally speaking, there is no person that is going to make decisions, that's going to contact people who can make decisions for you. Now, just like intestate succession, the state of Texas has a listing of people who can make medical decisions for you, right? And they start with your family, your spouse, your children, parents, etc. But if nobody can find those people, nobody knows where those people are, and you don't have anything listed on a document saying otherwise, then usually decisions are made by the ethics board themselves. And so that's kind of that you're sort of leaving it up to that. If nobody else can be found, if your family can't be found. Where should I store my documents? What good do they do you if no one knows where they are? I agree with you. They don't do you very much if no one knows where they are. So if you do have documents, if you have your will, your medical power of attorney, your durable power of attorney, if you have these documents and you have named agents, make sure your agents have a copy of them. They're the ones that are going to be acting under it. They need a copy. As far as your will goes, make sure your executor knows where your will is located, wherever it happens to be. If you put it in a safe deposit box, make sure your executor has a key and is listed as an owner on the safe deposit box. Otherwise, we have to go to court to open the safe deposit box to get the will out. That's an emergency order that we can request if we believe that there's a will in a safe deposit box and nobody else has a key and nobody else is an owner. Then we can ask the court to give us permission to get a court order for permission to go open the box at the bank. So if you are using a safe deposit box to hold your important documents, make sure somebody else has a key and is able to get access to it. Otherwise, there's no point in hoarding them, right? Scan them, send them to people who are going to be able to use them. To be honest, everything but the will can be used, like a copy is sufficient. You don't have to have it's not legally required that you have an original of a durable power of attorney, or that you have an original of a medical power of attorney, or even a trust. Those things do not require originals. And a will, it's easier to probate an original, but I can also probate a copy if that's all I have, right? So especially like during Harvey, a lot of originals got lost. And so probate in the after Harvey meant that we were probating a whole lot of copies because they just were scanned. And so we had a digital copy and we were able to use that, right? So it's possible to use that. So, share the documents. All right, so now we're getting into specific questions about how things work. So the first one's about wills. When does a will take precedence over beneficiaries? It does not. A will does not ever take precedent over beneficiaries. So there's two ways, really, that we leave our stuff to people. We leave it to people in a will, or we leave it to people by contract. And they do not interact with each other at all whatsoever. So if you have in your will, you say, I leave everything to my son. And then your retirement account says, I leave everything to my church. Well, your church gets the retirement account and your son gets whatever goes by your will. And that's it. They don't interact at all whatsoever. So if you name beneficiary designations, that's where it is going. The will does not counteract that. Even if you say in your will, I want to leave my retirement account to my son, but your beneficiary designation says that you're leaving it to the church, it's going to go to the church. The will does not control that retirement account because that is a contractual agreement that you are signing when you name your beneficiary when you name your beneficiaries, so when you designate your beneficiaries, I should say. So that is, it's always important when you're doing your estate plan, when you're figuring everything out, you can't rely on a will to change beneficiary designation. So if you don't know how you have your beneficiaries designated, that could cause issues for your estate plan later on. And that's part of the reason why you go to an attorney to get all of this done, is that you want to have an attorney to ask you the questions. How are those accounts designated? I can't tell you how many clients just knew where those accounts were designated, only to find out that that's not actually what they had written down. They did it 20 years ago and thought they had changed it and never had, right? So it's important that you review that as part of your estate planning. When is a will enough, and when is a trust a better option? So this is an excellent question in Texas. So in other jurisdictions, probate is painful and long and expensive. In Texas, it's not. It doesn't have to be. It can actually be fairly straightforward. A trust avoids probate. So in other jurisdictions, trusts are the end-all be-all of estate planning. And that makes a lot of sense in those jurisdictions. So if you ever see like Susie Orman, if you ever see, all of these different financial advisors on TV or on YouTube or whatever, and they're all talking about you have to get a trust, you must get a trust. Maybe it may not be as essential for you in Texas. Now, if you have significant assets and you are an elder orphan, and so you don't have somebody who can easily manage your money for you as you age, a trust is a good idea because you can name a trustee. You can name a person that is a corporate trustee, or you can name an individual if you have one that will be able to manage your trust assets. So the difference between a will and a trust is a will, all of the administrative duties are done on the back end. Right. So when you make a will, you state who your executor is going to be, you say where your stuff's going to go, and you trust your executor to collect all your stuff, pay all your debt, and give it to your people. And that's the will, right? It is a document that once you have created it and executed it, it goes in your drawer and you don't have to worry about it again. Your executor is going to be the one that takes care of everything.
Okay, so can I drop in for just a half a second? So one of the things that I learned from Angela, or we learned from Angela when we saw her in person, was that a will actually is about your stuff. You know, it's about just stuff in your house. It's about your house and your car. I always thought that personally that's where I said the money was designated. But it turns out if you designate your money through your banks or through your IRAs or Vanguard or whatever, it completely doesn't go through the will. So the will, and Angela, correct me if I've messed up something here, but when I realized that it was just my stuff, it opened up a whole new world of what I didn't have to put in to my will. That I could say different things in there if I wanted to, but it still was just about my stuff, tangible stuff.
Right. So it doesn't have to be just about your stuff. If you don't have beneficiaries designated on you, if you have a bank account with funds in it and there's no right of survivorship on that bank account and there's no beneficiaries, then it will also pass via your will. So it doesn't have to only be about your stuff. It can manage literally everything in your estate, but it cannot manage anything that you have beneficiary designated. So somebody asked the question, will a will override bank beneficiary form? No, it won't. The bank beneficiary form is the one that is the one that you have to that's the form that you have set by contract to say this is your beneficiary, right? And so it's really how you want to manage your estate and what makes the most sense for you. And for some people, avoiding probate makes sense, and we can do that in multiple different ways. And for some people, having just a will that will manage the things is all we need, right? And so that's a will. The administration is done on the back end by your executor. For a trust, the administration is done right now by you. When you are making a revocable living trust, you're basically saying, I am creating an entity. And as part of that entity, so let's back up. A trust is an agreement between three parties. The grantor, who has the money or the stuff, the trustee, who's going to manage the money or the stuff, and the beneficiary, who gets to use the money or the stuff, right? That's it. It's an agreement between those three parties. When you create a revocable living trust, generally speaking, you're going to be wearing all three hats. It's your money, you're managing it, and you get the benefit of it. So for those reasons, it is a tax non-entity. It is assigned entirely to your Social Security number. But the trust only manages assets that the trust owns, which means that as part of the administration on the front end, you go to the bank and you retitle your accounts into the name of the trust. You redeed your house into the name of the trust. You set beneficiary designations for your life insurance policies into the name of the trust, right? And so then the trust manages everything. And so that way, if you are incapacitated and you have a successor trustee, then the successor trustee can seamlessly step in and manage your estate as you age, and pay for your care, right? So the benefit of the trust in that case is that if everything is funded into the trust, you have sort of seamless management of your assets, and you can avoid probate. So you don't have to worry about going to court, dealing with probate, which again, it's not that onerous, especially not in like Harris County. It's very simple. And then, so you have a trustee, you can avoid probate, everything's all in one place. So sort of all your stuff's all together, right? That's the difference. For some people, I recommend a trust. I think it's a good idea, depending on who they have in their lives and what's going on. For some people, it's unnecessary, right? Because they're expensive, to be honest. Setting up a trust to begin with is going to be more expensive than setting up a will, because all of the work of the will, or a significant portion of the work of the will, happens in the probate part. And so you're basically paying for all of it up front when you're dealing with a trust, because you're managing everything. So that is, that's kind of the differences between a will and a trust. If you have assets that you are concerned about being managed as you age, and they are significant, in the $1 million, $2 million, $3 million, then talking about a trust is not a bad idea. That might actually be something worthwhile. And it's worth contacting an elder law attorney to sort of walk you through your options to figure out what's going to be in your best interest. Is there such a thing as a two-stage will, one for now and one for much later? No. If you execute a will, it is the will. If you execute a new will, if you execute two wills at the same time, there's no way to trigger one, right? It's the will that you have is the will that you have. If you execute two at the same time, usually the next one will just be considered like a codicil to the first one. And you can really confuse your estate plan. So estate planning is not one and done. People who think estate planning is one and done have been sold a bill of goods. It is not, because your life doesn't stop the moment that you sign your will. Things keep happening. New people come into your lives. Old people leave your lives. You move, you get more assets, you lose some assets, things change, which means that your estate plan over time is going to change. When you were younger and you had young kids, you had to worry a whole lot about making sure there were guardians in place. And then you had to make sure that there were trustees for your kids' trusts in case they needed it later on, right? To manage that money until they become old enough to manage it themselves. When they become adults, now you need to change it again so that you're relying on them to be your executors and your trustees, maybe, right? If they're trustworthy and you can, then that's what you're going to be changing it to. And so each stage of life, you have to revisit these estate plans. It is not something that you do once and put in a drawer and never think of again. I know a lot of people want it to be that way, but it can't be. There's too many things that happen in people's lives. Now, sometimes you could pull it out, dust it off 10 years later, review it and say, yep, everything is still the way I want it. Everything's still going to the people I want it to go to. The people I've named as my executors are still the people I want to manage my stuff. And you put it back in your drawer, and that's fine. But do dust it off periodically. And then if you decide, you know what, there's some changes that need to be made, then have those changes. But get it out of your head that you do this one time and then that's it. Right. So it's not one for now and one for later. It's one for now. And then later you can do another one. Or is it just a matter of listing several executors in sequence? Stack them up like dominoes. If you've got multiple people, especially of multiple generations going down, right? If there are multiple people of multiple generations going down, that is great. If you know that, if your concern about making a will right now is that you have to name one executor, and that executor is like a sibling who's going to be aging same time you are, right? Then put in place people of the next generation down. So name your sibling first, that's fine. But then name nieces and nephews below, right? Kind of make sure that there's sort of a safety net of people that you can rely on. 3 successors is fabulous. 2 successors is fine. Only 1 executor can be problematic. It's really good to have a couple. And you want to make sure that there are some of the younger generation just in case, because you could outlive all your friends. You could outlive all of your siblings, all of your family. And so you need somebody of that younger generation who's going to be able to step up. And these are conversations you kind of have to continually have with the people in your life, right? Right now, maybe your nieces and nephews aren't old enough, but in 5 years, there might be one that is. And so maybe that's when we decide we're going to revisit the will and make some changes. We can only plan for what we have right now, but we can kind of look towards the future about what might be able to happen. Yeah, having a sequence of executors does not complicate matters at all. It actually makes my job in probate so much easier. Okay, trust. Revocable living trust versus irrevocable trust. Okay, there are so many kinds of trusts out there that are used for so many different things. Usually in estate planning, we're talking about revocable living trusts. Again, they are tax non-entities. They don't affect your ability to keep your homestead exemption on your house. They don't affect your ability to manage your property in any way, shape, form, or fashion. Irrevocable trusts are, for generally speaking, more intense kinds of tax planning. Or for other reasons. Special needs trusts are irrevocable if you have an adult child with special needs that you are trying to put money away for, right? Or if you have a young child with that will have special needs and you want to make sure that you put money away for them in a way that's not going to jeopardize their benefits, right? Those are all different types of irrevocable trusts. Whether or not you need a revocable living trust versus an irrevocable trust entirely depends on your circumstance, your situations, and your goals. So that's really not a question that I can just answer in a vacuum.
Angela, this might be a good time to talk about pet trusts, because we have a number of people in the group. And so since we're talking about trusts, could we talk about that?
Yeah, absolutely. So one of the things that we can do if you have pets, we have a statute in Texas that says that we can create pet trusts. And what a pet trust is it's an ability to either in your will or in your revocable trust, whichever one you choose to do. It gives you the ability to name a caretaker for your animal and set aside, or animals, and set aside a certain amount of money for their care. Right. So for like food, vet bills, et cetera, because I think a lot of the hesitation that some people have with caring for their pets after they're gone is they don't necessarily want to give it to somebody and then that somebody then has to carry the burden of the expense of having an aging pet. Right. And so you can alleviate that burden, making it a little bit easier to name a caretaker to take care of your pet by setting up a pet trust and allowing naming a person who's going to be the caretaker, and that person can also be the trustee, or naming a separate trustee to use the funds that you've set aside for your pet to keep them healthy and happy once you're gone, which, that's already a sad thing for your pets. So that is something that you can think about, and it's always things that we can add in your documents if necessary. Affordable paid fiduciaries that handle smaller portfolios of assets and manage retirement accounts, individuals, institutions. So this word fiduciary, in my world, it's a little bit different, I think, than what you're asking. So there are individuals and institutions who can do like investment, right? So like financial advisors. They do exist. A lot of them do handle smaller ones, but you have to find the individuals that will and manage retirement accounts. They're few and far between. As far as naming paid fiduciaries to act as your agent under durable power of attorney, those are also few and far between. We don't have good resources for people of modest means to pay for this kind of work, primarily because it all comes with, so for on the financial advisor side, it comes with it's not a big money maker, right? Because they get a percentage based on what sort of income they're able to bring in for you, and the less money you have, the less money they're able to bring in, right? So it's less profitable for financial advisors. For professional fiduciaries on the other side that are there to make decisions on behalf of your estate while you're alive under durable power of attorney, they have personal responsibility and personal liability, which means that if anybody in your family does complain at some point in time that they don't like the way that the professional fiduciary is taking care of your business, then that's an issue. They can be sued. And so a lot of people are not willing to, most individuals are not willing to step up as like paid fiduciaries, including like executors of your will. That is a hard one. You can find some people sometimes, but it is, our options are limited, I guess.
Okay,
Does the pet trust have to be a trust, or can it be just part of the estate plan? It is just a part of the estate plan. It's in the will. The pet trust is just like a little section in the will that says pet trust.
okay, so you may have answered a question. Carla Ankafer says, does the pet trust have to be a trust, or can it just be part of the estate plan, including indicating the amount of money to go for the care, et cetera, that is binding, so the executor can't take the money away?
Yeah, so that's the little part of the trust that's in the pet trust, that's in the will. It just says how much goes in trust and who the caretaker of the animal is. It's not a separate document. It's not this big, huge separate thing. It's just like a little paragraph or two in your will or in your trust that says that this is a specific gift, right? So it's just like if you were giving $5,000 to charity, it would say $5,000 to this charity. And if you're giving $5,000 in a pet trust, it says, you know, I'm giving $5,000 to the trustee of the pet trust. And then my caretaker is going to take care of my pet.
Is it possible to also just allocate a certain amount of money to the individual who you've identified as taking your pet in the event of your death?
Of course, you can allocate whatever you want. It's your money, right? There's no way, if it's not in a pet trust, then you can't guarantee it's going to be used for your pet's care. If it's somebody that you trust to take care of your pet, then sure. Like we have pet trusts specifically so that we can have a binding document that says this money is to be set aside for care of my pet.
Yeah.
That
makes sense.
Yeah. But you are
but if it's like a lifelong friend that you
Mm-hmm.
have a handshake agreement, Vicki, right. I'm going to give you $10,000 to $20,000 that's just yours because you're going to take my cat.
Right.
And I trust you to use that money for her care.
That's right.
Yeah.
You can absolutely do that. You cannot guarantee that they won't take your cat to a shelter when you die. Right.
I will come back and haunt her ass so hard.
And that
she knows it.
Right. And I think that is and that's right. Like that is a perfectly fine approach when you have people that you can trust to do this and that you know are going to take care of them. That's absolutely one way of doing it. Okay, so what's the difference between co-signers and pay on death beneficiaries? All the difference. There's like literally nothing that's even remotely the same in there. So on a bank account, if you have a co-signer, so first off, there are many, many ways to set up a bank account with another person. I don't mean to confuse you all, but I really want you to understand that until you call your bank and verify how you have your account set up with other people, you may not know how you have your account set up with other people, right? So we have joint ownership with right of survivorship. That is usually what most couples have when they have their accounts together and both names are on it. Both are your joint owners with a right of survivorship. And that means that when one person dies, the other person just automatically takes control of the account. There's a right of survivorship. Done. There are joint owners as tenants in common. What that means is that they're joint owners, but there's no right of survivorship, which means that when one dies, half of that, like the account gets frozen until we figure out where the account's going to go and what's happening with it. Okay, that actually happened to a married couple clients of mine. They did not realize it was not owned in a right of survivorship. And when we went to go take care of everything before the probate, the bank was like, I'm sorry, we have to freeze this because it's tenants in common, which shocked me because that 99% of the time, as between a married couple, it's always with right of survivorship. So I have no idea what happened there, but it was tenants in common, and that was devastating. So know what you're like, how it's set up. And then you have bank accounts that you own all by yourself, but that you have named somebody else on as a co-signer. So in the other two that I mentioned, they are joint ownership, meaning that the other person has an ownership interest in that money. So they own part of it legally. In a co-signer situation, the co-signer simply has access to the funds, but they are not considered a joint owner. So that money is not theirs. They're just being allowed to write checks to pay bills, right? And that's it. That's what a co-signer relationship is. When a person dies and all that's left is the co-signer, that co-signer has no right to that account at all whatsoever, unless they are also named as the pay on death beneficiary, right? So the co-signer has no right independently to anything in that bank account. Only whoever has a joint with a right of survivorship or a pay on death designation has a right to whatever's in that account. So I'm going to caution y'all, when you have other people on your account as joint with right of survivorship, make sure that's the person you want to get all of it. Because I had a situation where mom had 4 kids, about $400,000 in her bank account, and she had one son with her on the account with a right of survivorship, so he got all $400,000. Well, he knew, and she knew, and everybody knew that he was going to split it equally amongst his siblings, because that's what he wanted to do. He wanted to do right by mom, and that's what she wanted, everything to be split equally, and he was happy to do that. Except now he's gifting more than $17,000 a year, which means he has to file a gift tax return, and he has to do all of these other things. And so you run into one of two situations when you have a right of survivorship on an account that you expect the survivor to split with other people. Either they don't split it with other people and they don't have to, or they split it with other people, but because of the way the split is, now they have to go to an accountant and take care of tax issues that they wouldn't have otherwise had to take care of, right? So don't necessarily have to pay taxes. It just means that they have to, now they're gifting over a certain amount. And so again, when you're setting up your estate plan, it's really helpful to go talk to somebody about how you have things done, because these are unintended consequences of trying to make it easy for your family, right? It was very easy for the siblings. It caused a little bit of a headache for the person who was actually having to deal with it. So whenever you're dealing with anything like that, it's important to go talk to somebody who's been through this, who can kind of guide you in, here are all the ways this could go wrong. You make your decisions however you want, but just make informed decisions, right? That's the goal. The guardianship designation in the event of incapacity. So this is a document that we do, and we hope we never need. In Texas, we have 2 kinds of guardianships. Guardian of the person, which is somebody who is going to make decisions regarding where you live, who your doctors are, when you go to the doctor, your day-to-day life, right? That's the person. And then we have guardian of the estate, which is the person who is going to manage your money in the event that you lose capacity or are not able to manage it yourself. We want very much to avoid guardianships at all costs. They are incredibly onerous to the individual and to the guardian. But if we can't avoid it any other way, because of abuse, exploitation, self-neglect, whatever, then we go to court and we tell the court, or we give the court evidence from investigators, from doctors, etc. And the court determines that a person is in need of a guardian, of the person or the estate or both, depending on the circumstances. This document, the guardianship designation in the event of incapacity, is a document that your person can take to the court and say, look, they've lost capacity, and they created a document that said if they ever lost capacity and a court ever deemed them to be incapacitated, they had a chance to choose who they wanted their guardian to be. and they chose this person, right? So it gives you an opportunity to tell the court who you want to be in charge of things if a guardianship is ever necessary. This document does not say that you are agreeing to a guardianship. It does not create a guardianship of any kind when you sign it. It doesn't do anything for your estate plan at all, except allows you to take control of who gets named in that position if all other control has been lost. And the very important thing about this document is that you can choose who you do not want to be your guardian. I did not realize until I started really practicing in this area how popular that option was going to be. There are a lot of people out there who want to exclude people in their family from being their guardians because they just don't trust them. And that is perfectly reasonable. So we make sure the court knows, under no circumstance do I want this person to be my guardian. You don't have to say why. You can just tell the court, I want them and not them. And that's it. So it's a very useful document.
Okay, I need to drop in here for a second if I could. So we've got two questions.
This power of attorney. So they have their own policies in place. And sometimes that means we have to go back and forth, right? Sometimes it means that you give them a document. They can choose not to accept it. If they choose not to accept it, they have to tell you, but they have to tell you in writing and they have to tell you why. And then we can go back and forth and back and forth. And you generally have to get an attorney involved until ultimately, if they won't accept it and you've followed all of the statutory like due process that you have, then you have to go to court. So accepting powers of attorney can be really challenging. I give my clients advice when they're signing their durable powers of attorney to name an agent, to go into the bank with the power of attorney and the agent and introduce them to the people at the bank and say, this is my agent and here's my durable power of attorney and I want you to scan it and I want you to put it in my file so that when my agent needs to use it, you know that it's already here. And then ask if there's any additional paperwork that you need to file to allow that to happen. So institutions don't accept it again because they don't know, they're not attorneys and they don't know the legal parameters of it and they don't want to get in trouble. As far as medical powers of attorney and HIPAA authorizations, I cannot answer that question. I've not had a lot of issues at hospitals themselves not recognizing the agents under a medical power of attorney or the agents under a HIPAA authorization. I don't think I've ever had anyone ask a patient that was unable to communicate their wishes to sign documents, but I don't know what documents they were having them sign. Like that's a sort of a nebulous question to me. As far as why, in my experience, hospital staff are happy to have a medical power of attorney on hand so that they can talk to an individual person. They're happy to have a HIPAA authorization so they can talk to an individual person. So that's a unique situation for me. Because as far as I know, doctors are not particularly excited about making decisions for patients if there's somebody else who can make the decision for them. So I apologize, I can't really answer that question.
Well, I just have a comment. My name is
Sure.
Jeanette. I'm an attorney and I do a lot of these documents for a lot of people. And it was a personal friend of mine that was in the hospital and they wanted to bring a whole set of other documents, medical power of attorney, HIPAA and so forth. And my friend was, very sick and out of it really. And I said, look, I have these documents. What I found with all these institution banks or hospitals or whatnot, if they ask you for it, it's different. You're treated differently than if you provide it without them asking. So I kind of don't say anything unless they say, where's this paperwork? And then I give it to them and everything's great. So that's kind of what just happened to me recently.
Okay, interesting.
Mm-hmm.
Yeah, I wish I knew. There's this idea that if you have a document and it says that it should do what it says it does, and that somehow it magically should just do what it says it does, but it doesn't. There's no there's no magic to these documents. They are what they are. And if somebody is going to not accept it, then you can't force them. Like, there's no magic wand to force them to. You just have to follow the process. It is onerous, to be sure. All right, healthcare, advanced directives, medical powers of attorney, healthcare proxies, directed to physicians, living wills, do not resuscitate orders. All of these are medical documents that we can do. We've talked a little bit about the medical power of attorney, and the HIPAA. The medical power of attorney is decision-making document, right? So it's a document that says who gets to make medical decisions for somebody if they are not able to communicate their own decisions. The HIPAA authorization is an information gathering document only. It's not meant for decision making. It's just meant for somebody to be able to, for a doctor to be able to communicate with somebody other than the principal, other than the person there. The directed to physician is the same as like the living will. Like people, I hate the term living will because people get it confused with the last will and testament. But that's the physician's directive is my preferred term for it. And it's basically a document that says whether or not you want to be kept alive on artificial life support if the prognosis is really bad. So it comes into play under two circumstances. First, you have to not be able to make your wishes known. And if you're in a state where you can't make your wishes known and the doctor says that you are terminal, meaning that you're not expected to live longer than 6 months, no matter what they do, you can say, keep me comfortable and let me go, or keep me alive as long as possible. If the doctor says, this is incurable, meaning we've literally given every treatment that we can think of, and it's not going to get better, and they're going to stay in this state indefinitely, then again, you can say, keep me comfortable and let me go, or do everything in your power to keep me alive. Right. So that's the physician's directive. It's generally not an emergency kind of document, unlike a DNR. So I don't create DNRs because your physician has to sign off on them. A do not resuscitate, the way a do not resuscitate has been explained to me. It's really funny. I have a friend who's a geriatric physician, and she said she doesn't touch physician's directives. And I'm like, well, I don't do DNRs, right? So we just kind of like refer out. So a DNR, the way she explained it to me was if we were having lunch and I was choking on a grape and I had executed a do not resuscitate, then she couldn't perform the Heimlich because that would be a heroic measure, right? And so that's how it has been explained to me. A DNR is for people who are ill. They are sick. They don't want the heroic measures to bring them back if they are in a situation where it's there's something happening, right? Like a heart attack or choking or whatever. And that's something that you talk to your doctor about, right? It's something that it's a conversation that you have with your physician. The physician's directive is not an emergency document, right? There has to be some time to evaluate your circumstance and decide if you want to have life-sustaining treatment withheld or withdrawn. So that's kind of the differences in those two documents. Either way, they are guidance for your agents and they're guidance for your family about what your wishes are. And ultimately, when it comes to these documents, it's not a best interest standard. Unlike the durable power of attorney when it's talking about your money, which is what's in the best interest of your estate and for you, these are the standard for medical powers of attorney is what would the person do if they were awake, aware, and able to make the decisions for themselves. And the goal is to try to step into the shoes of the person who is not able to speak for themselves and to make the decision that they would make. That is really difficult to do. I know that, people who have really close families, like they're usually one or two people in the family, like, oh, no, they know exactly what I want. Like they would be able to make the decisions for me. Okay, great. A lot of people don't necessarily have that. And it requires having hard conversations with people about your values, about your wishes, about what you want to have happen. These are not, to me, that's the hardest person to name. All the rest of it is stuff, right? Your durable power of attorney is the most important document you can have. Your medical power of attorney is the hardest one to really determine what it is that you know, how you want to be treated, and what you want your aging to look like, and what sort of decisions you want other people to make. And so that one is a little bit more, to me, it requires a lot more thought, I guess. None of these documents are throwaway documents. None of these documents, like, people like to pull them offline and then just sign them and be done with it. And let me tell you a horror story about that. So a durable power of attorney document was signed in Texas. The form has these enumerated powers, A through O. And if you initial by O, then it says, you know, I agree to all of the powers above. There's no need for, like, all of the powers. They're just regular statutory powers. I had an agent bring me a power of attorney where the principal had initialed by N, which is the one right above it, which is the ability to manage digital assets. That is all this agent could do, was manage digital assets. They could manage the Facebook account, and that was it. We couldn't sell the house. We couldn't deal with stuff. And so it is really important to be very specific about when you get these documents done. I know that they are available online. Know what you're doing. Read it. Go to an attorney. Have somebody walk you through what it means. That is absolutely crucial. Okay, do we need all these documents? Yeah, you do. That these documents are necessary. They all do different things. So the question is, you know, thinking about feeding tube for 3 days, 15 days, ventilator for 24 hours, 15 days. So I've had nurses fill out their physician's directive, and there's like this special instructions part, and they are detailed with, this is the kind of treatment that I want. This is what I don't want. Under no circumstances am I to get this treatment or this treatment. As far as like the days, I guess it would depend on what your prognosis is and what your diagnosis is. Is that something that you want to do? Do you want to tie the hands of your people by putting days on it? That's a question, like, that would have to be a discussion as far as like why that would, when and how we would do that. So, all right, so I have a question. All my kids have the ability to go into my bank account and transfer money into their accounts or withdraw. They are also beneficiaries. Do I need both? Would one be better than the other? I could also give them a blank signed check to withdraw money. Okay, you trust your kids a whole lot. That's awesome. If they are on the accounts as joint owners, and so able to do whatever they want to with the money that's in the account, then they don't necessarily need to be beneficiaries. It's a belt and suspenders approach, I guess. If they're already right of survivorship, then they each are going to survive the others until there's only one left, right? There can be only one. As far as which one's better, it depends on what you need them to have access to your bank account for, right? Are they?
So what I'm thinking is, if I get hit by a car
Mm-hmm.
and I'm in critical condition, I want my kids to just be able to go into my bank account, because I have absolutely nothing. I really have no, I don't even own a car. I have nothing. All I have is my money that's in my bank account and a life insurance policy.
Mm-hmm.
On my life insurance policy, and they're my beneficiaries. But they'll have to pay for a coffin, and they'll have to, so I just want them just to take all that money out. Yes, I trust them with my life. Yes, I do trust my boys. Take it out, and just use that money. I have one son's going to be a power of attorney financial, and the other one's going to be a medical, because one's better with the money than the other. And that's kind of how I was thinking. But then I wasn't sure, well, okay, if I do that, is the government going to come in and say, you know, she just died, what happened to her money? Or
No, the government asks no questions.
okay, so if my kids just emptied out my bank account, that I don't have to worry about any kind of probate or anything like that, because I don't own anything.
If they're named as right of survivorship, then they have equal rights to those funds. And that's
I
it.
have it as both. So is one better than the other? Like,
Again,
know,
better depends on what your goals are. If you want them to be able to use funds to do the funeral, having it as a right of survivorship makes sense, right? So they can immediately access it. They both have a legal right to it. They could both legally write checks out of it. In beneficiary designation, again, it just goes out to the beneficiaries. It passes by contract. There's no government involvement. In probate, the only people that care are the other people that are getting stuff, be it creditors or whatever. There's no, as long as Social Security has been notified of your death, and they can, if they put money in and they have to pull it back out, they get to pull it back out. That's all that matters, right? Because I have seen claims of fraud against Social Security when somebody kept money that should have been clawed back.
that's if they don't call them and let them know that I died.
But the funeral home usually does that. Well, no, but sometimes you call them, you let them know that you died. They'll still deposit the money in your account, and they'll still take it out the same day, or a day later or whatever. So I'm just saying, be careful about Social Security if they're going to be accessing the account after death, but they have our legal right to it. So there's not, again, I'm not giving legal advice on this one. I'm just saying that if you do a beneficiary designation, then you have to wait until you get the death certificate before they can distribute it to you. Right. And so depending on what your goals are, there's no agency or boogeyman or any body that's going to be necessarily involved unless your kids start fighting, right? And if your kids start fighting, then all bets are off. I can't, that's a whole different scenario. But that's really that's who cares in these circumstances. There's no agency that cares.
Perfect. Thank you.
You're welcome. I have a financial planner. I gave him my estate plan so he and my executor can communicate with ease. Yeah, that's a great idea. Making sure all your people know each other is fantastic. Making sure that your estate planning attorney knows who your financial advisor is, knows who your accountant is, knows who your geriatric care manager is if you have one. That's great, because then but make sure that you give your estate planning attorney authorization to speak to these people after you die, because the attorney-client relationship survives death and privilege survives death. So if you have not signed something allowing your attorney to disclose information after your death to your estate planner, to your family, to your executor, whatever, then technically they cannot, which comes up all the time. Executors go to attorney's office and like, okay, I'm the executor, I need to have a copy of the will. And if there was no disclosure, then you don't get it without a court order. So that's, make sure that if you're working with an attorney, an estate planning attorney, and you want them to have access, or you want them to be able to talk to all of your people, make sure that you've signed those forms giving them authority to do that. Does the POD bank account beneficiary need a death certificate in order to get the funds? Yes. Generally speaking, although that's going to be a policy of the bank. I say yes as if that's universal. It's a policy of the bank, right? However the bank does it is how it has to be done. Generally speaking, they are going to require having a death certificate before they will release funds out of somebody's account. because they got to, you know, I mean, for their own records, they got to prove that you're dead, right? I mean, otherwise they're giving money to somebody who doesn't legally have a ability to take it. So
But a
that's,
way around that would be like, if I know I'm in my final hours and I want to make her a just a name on the account, and then she has all access, right?
so again, it's if you decide to make somebody a joint owner with right of survivorship, then they legally have the ability to access everything in the account. And then when you pass, then everything in the account goes to that person
Okay.
for better or worse, depending on what
Yeah.
you want.
Yeah.
I, you know, when it comes to setting all of this up, I do highly recommend contacting an estate planning attorney to make sure it all harmonizes the way that you want it to be. But as far as how it works legally, that is how it works.
Okay.
In hospital and out of hospital forms. So here's another thing about the DNR. If you have a DNR, an in-hospital DNR, you also have to have an out-of-hospital DNR. It's two separate documents, and the doctors have to sign off on both. So like, for example, if you're in independent living or assisted living facility or retirement community or whatever, then you have to have the out-of-hospital DNR as well if you have an in-hospital DNR. They are not the same document. And there is no guarantee that it's going to keep you from being intubated, because Lord knows I've seen that too. But at least you have a document that says that you didn't want that. HIPAA release, we kind of went over. Again, whoever it is that you want to be able to talk to your physicians on your behalf. That's who you put on the generic HIPAA release, and then make sure your doctor has a copy. Organ donor statements, depends on if you want to, like how you want to donate your organs. We can also just, in the special instructions part of the medical power of attorney, we can also put organ donation, right? You can have it on your driver's license. You can do that anyway. There's no need to have a separate document necessarily for that one. Disposition of remains, prepaid end of life arrangements and contracts. I'm a big fan. I'm a big fan of prepaying and pre-planning your funerals. And I will tell you why, because it is one of the kindest things that you can do for your family. They're insurance contracts. You go into any funeral home around, most of them are owned by the same overall company, like the same basic company. And so, you know, it's all pretty much the same. You choose what you want. You go ahead and pay for it ahead of time, so it's inflation protected. That's the selling point for the people who do this kind of sales. But more importantly, you make all the elections, right? You decide what you want, and so your family basically can pick up the phone, call a number, go to your services, and things are already kind of happening. They don't have to sit in a room with a big wooden board table looking through a catalog to figure out what color your coffin liner should be. And I say that because I went through that with a friend when his wife died young. I went for moral support, and that is what we did at the funeral home, is we just kept looking through catalogs for specific things, and it was heartbreaking and infuriating, honestly. So just do that ahead of time. Just get all that done. How will you know that your wishes are going to be honored? Well, if you prepaid it and you've talked to the person and they've like checked all the boxes, then that's how you know, because they're the ones taking care of it. Otherwise, you just write stuff out and you trust the person that you name as your agent. If you don't trust the person that you've named as your agent to carry out your wishes, then you can't trust your wishes are going to be carried out. That's just the best you can do, is name a person that you trust and give them as detailed instructions as you can, and hope that they honor them. To my knowledge, there's no like legal action someone can take if someone else doesn't honor your funeral wishes. But I don't know, like that's never come up before. Usually when the appointment for disposition of remains comes up, it's because a family is fighting. There's usually a step parent and then children from a previous relationship, and they want to know who gets control over the spouse/parent, right? And so we always look to that document. Is their appointment for agent of disposition of remains? Yes. Well, then that is the person that gets control over that individual, right? That's usually when we run into litigation with dealing with the funeral services. Okay. Do I need to make arrangements for a car I'm still paying for? Yeah, so we have, if you go to the DMV's website, there's beneficiary designation for motor vehicle. And basically what you do is you can designate somebody as the beneficiary for your motor vehicle, and you go to the DMV office and you pay them like I think it's $36. There's 2 forms you have to fill out. And then when you die, then that vehicle goes to somebody else, goes to your beneficiary. And so that way you can kind of, you can name somebody. They can then, the title will pass to them. Now, how it works with the car, with the car company, or with your, like, who you owe the money to, the lien holder, that's going to depend on their policy. Generally speaking, as long as somebody is still paying the payments, then it's not usually a big deal, but naming a beneficiary at least puts somebody in charge of taking care of the vehicle. What documents require a notary public? So the will, if you're going to do a self-proving affidavit, requires a notary public. This is one of those it depends questions, right? So if you have 2 witnesses who aren't your physicians or nurses at the hospital or working at the hospital and admin, then you can do a medical power of attorney without a notary, but you have to have 2 witnesses and they have to meet these certain criteria. The HIPAA authorization, I believe you can also do with just witnesses and not a notary. All of them need something, right? Either witnesses or a notary, depending on what it is that you're trying to get together. You can also transfer real estate. Oh yes, transfer on death deeds. Huge. Love a transfer on death deed. Big fan of a transfer on death deed. Basically, it's setting up a beneficiary designation for your house. And if you're trying to avoid probate, like you have your beneficiary designation set up on your bank account, you have your beneficiary designation set up on your retirement accounts and everything else, and all you have is your house, do a transfer on death deed, set up a beneficiary designations for your house. That has to be filed. So unlike other deeds in Texas, the transfer on death deed has to be recorded before the day of death in order to be valid. So don't wait until you're literally on your deathbed to fill one out. They are meant to be an easy way to transfer just a house. I use them all the time in my estate planning, just because it does make things a lot more, it just makes things more simpler for your house. Yeah, so there's so many, like, if you really, really want to avoid probate in Texas and you don't really think a trust is necessary, there are many ways to do it. It doesn't mean I wouldn't also have a will, because if you have an orphaned asset, then you still need to deal with that. But otherwise, that is, So somebody asked the question, what is a Ladybird deed? A Ladybird deed, let me see if I can do this without getting too in the weeds. A Ladybird deed is an enhanced life estate deed. So it functions the same way as a transfer on death deed. The differences are legal. Whether you need a transfer on death deed or a Ladybird deed is going to entirely depend on your circumstances. Both a transfer on death deed and a Ladybird deed will protect your estate from Medicaid estate recovery, because Medicaid can only recover against assets that go through probate. So non-probate assets are, generally speaking, well, no, not generally, non-probate assets are going to pass outside of Medicaid estate recovery. So, but a Ladybird deed can, if the power of attorney authorizes an agent to do certain things outside of the regular statutory powers, but like a more robust power of attorney document, then an agent can sign a Ladybird deed for somebody who is incapacitated. An agent cannot sign a transfer on death deed. So it really, like, there are legal differences between the two documents, and there are reasons to use one or the other depending on your circumstances. This is definitely one of those issues where I highly recommend contacting an elder law attorney to know if there's a reason to use one over the other in your particular circumstances. But both of them are great for passing property outside of probate and ensuring that you can protect your estate against Medicaid estate recovery. What's a pour-over will? So a pour-over will, very simply, is just the will that we have for a trust to collect orphaned assets. So we have a trust and we fund the trust fully, and we hope that there's nothing left outside of the trust, so that when somebody dies, all of their assets are just managed by the trust. We don't have to go through probate, no need to go to court, no need to name an executor. The trustee just manages it all. But inevitably, we have this little thing of mineral rights that have only kicked off $25 a year for the past 50 years, and we forgot about it, right? When we were doing the estate planning, it just didn't come up because it's this little bitty mineral rights thing. And so now we have this little bitty mineral rights thing. Your pour-over will says, okay, we can probate the will and we can transfer that mineral right into the trust so that the trust can manage it, sell it, do whatever it needs to do. So that's what a pour-over will is. If you pour orphaned assets into the trust after death. So anytime we do a trust, we always do a pour-over will as a belt and suspenders approach, just to make sure we manage any assets that have been inadvertently left off the trust asset list. Anything else? This has been fun. I'm sad I didn't get a chance to see everybody's faces. I like to see everybody's faces.
I'll turn on your cameras again. I think we don't have, unless we have some more questions, and if we do, we can just say. But Angela, this has just been great. It was even better than, well, not even better than the first time. It's just more expansive than the first time in some ways. And I'm glad we got a chance to talk about that. The transfer for the homestead, for your house, it makes life so much easier. Just everything gets done quickly. So, okay, anything else? Anybody want to make any comments about it? If not, we're going to let Angela go. We're just about on time. We're a little bit early, so you can all watch our TV programs or whatever you were up to.
Angela, are you a person to whom we can come for will revisions? Is that something that you do?
Absolutely. Yes.
Okay.
I do all estate planning. I also do elder law. So part of the elder law I do is Medicaid planning. So if there are issues where you think you might need benefits in the future, planning for those benefits now and putting things in place, I can help with that as well.
Okay. And who has your contact information?
It's up at the top of the chat. I stuck it.
Excellent.
There.
Thank you. Appreciate that.
Yeah, she also does, you didn't say, Angela, so I'm going to give you a commercial. So when you call her, you can have a consultation. So I did this, and Angela, I'll let you talk about the money part of it, but it was really worth it. If you don't do any more than the 1 hour consultation, you're going to get a lot out of it. But if you go further, it's going to be included in the cost of the will. So Angela, I'll let you do a commercial for yourself now. We would like you to do a commercial for yourself.
Yes, thank you. So yeah, so if you I do paid consultation. It's an hour long. You give me your information in a questionnaire, and then I go over all your stuff and we ask all the hard questions, and then you decide what you want to do moving forward, how you want to move forward. If you decide to move forward with a full estate plan with your will and everything, then the consultation fee, which is $400, is wrapped up into the cost of your estate planning. If you just get the advice out of that hour and you're okay moving forward, then it's just the consultation fee, and that's that. But I attempt to be comprehensive in that hour, at least kind of giving you what all your options are, so that, again, you can make informed decisions about how you want to manage your estate.
Yeah, I want to add here too. I said that you get more than just legal advice there. So she asked some really good questions that I personally had never thought of. And so like everybody, I have a house. I just think you're going to have to scrape me out of this house when I go. That's just how it's going to be. But she pointed out that that may not be the case, that most of us don't have that happen unless something traumatic happens to us. And her question to me, and among many questions she asked, was, what is the trigger point that you have to leave your home? What is the trigger point that tells you this is not viable anymore? And do you have a plan for that now? It's like, that was some of the most valuable advice, because I did think you were going to have to scrape me out of this house, but if they don't, I better be prepared. So
yeah, long-term care. What do you want your long-term care to look like? What do you want your aging to look like? And at what point are you making different decisions? What's the trigger for when you're going to give up the keys, right? When are you giving up the keys, and what's your plan for that? What's your trigger for when your house is no longer safe for you, or when you just simply can't take care of yourself in your house anymore? Like, at what point in time? You may never get there on your own, but if you talk to other people about what your triggers are, then they can hold you accountable. And they can say, hey, you know what? You talked to me about this, and you said if you got lost one more time coming home, that you were going to think about giving up your keys. So are we giving up the keys, right? I mean, having other people hold you accountable to your decisions is really helpful for making these choices. And if you never think about it, then they come upon you so fast, and it's so upsetting, and you don't know what to do because you've never given it any thought. And now all of the control has been taken away from you. All of the sort of decision making is being taken away from you, because you're left with having to make choices that you didn't want to have to make. And so if you take time to think about what your next steps are and when it's going to be appropriate to take those next steps, then you're going to be better off for it. Whether or not you ultimately follow up, that's going to be on you. But if you've had an opportunity, if you've taken the opportunity to think about it, then at the very least there might be something later on where you're like, you know what, I always said if it got to the point where I couldn't do this thing in my house anymore, that I was going to look at, maybe a retirement community or a smaller house or whatever. And then it's like, okay, maybe now is the time to look at that, right? And so you give yourself deadlines in that way. You give yourself triggers about when you think about these things.
Angela, I have a question.
Really important. Mm-hmm.
So short of coming to you for all of our documents, which I'm going to try to do this fall, the sooner the better, what are the documents that we can go ahead and get done by ourselves that we should do first?
So, okay. Technically speaking, all of the documents are available. Even the Texas Supreme Court has created a will form. Estate planning attorneys are quite thinking about how horribly messed up people's estates are going to be because they use them. Medical powers of attorney, HIPAA authorizations, I have no problem with you pulling the ones offline. Like, those are pretty basic. I don't generally draft anything additional into them. Your wills, your durable powers of attorney, go to somebody who knows what they're doing. I draft a lot of additional powers into my durable powers of attorney, because I have seen too many instances where an agent wanted to do something to make sure that the principal could get qualified for Medicaid or could do something specific. And they just didn't have the power to do it, because they just pulled the document offline and initialed where they thought they should initial and then signed it. And that was that. So I cannot recommend that you do either the will or the durable power of attorney. The medical power of attorney, the HIPAA authorization, those you can get usually from Texas Health and Human Services website or texaslawhelp.org. Both of those are good sites for those kinds of documents. The designation of guardian, you could, prior to need, you can do, because and again, it's one of those things where, you know, unless you're going to be excluding people, then I recommend that you see somebody. But if you just know who you want to name, then that's a document that's not, it's a statutory form. It doesn't have anything specific that has to be drafted in. That's pretty much it. I would say those 3 documents, physician's directive, right? Whether or not you want to be kept alive on artificial life support. But if you have special instructions, then again, I would say contact somebody and talk about what those special instructions are going to look like. I have clients of all kinds of religious backgrounds that have very specific instructions for how they want to be, for what medical interventions they want and how they want to be treated. And so if you're going to do something like that, then I recommend, you know, contact, like coming to your attorney's office and doing it all there.
What are the documents that are in your package, if you don't mind?
Everything I just said. Yeah. The will, the durable power of attorney, medical power of attorney, HIPAA authorization, physician's directive, designation of guardian prior to need, and appointment of agent for disposition of remains. And transfer on death deed if you want to. That's extra, but absolutely that can be part of it.
What was the last one? What was that last one?
Transfer on death deed.
Okay.
For the house, the transfer on death deed for the house.
Okay, great. Thank you.
During our last meeting, someone thought there was a $100,000 cap of protection. Protection from what?
I think she's talking.
For Medicaid, for Medicaid state recovery? No, there's no cap on Medicaid state recovery. If the house or any assets do not go through probate, then they are protected from Medicaid state recovery. There's several things that can protect your estate from Medicaid state recovery, but one of those exemptions, or rather just the blanket understanding, is that non-probatable assets are not currently subject to Medicaid state recovery. I am in Bel Air. I'm right off of 610 and Bel Air Boulevard.
I'm totally coming to see you.
Okay. Thank you. Lovely. I'm happy to see any of you. The reason I do this is, you know, I am definitely happy to help out and have the business, but this is an education. This is an exercise in education, because few enough people really have an understanding, and why should they, of these documents and how they work. We never talk about aging. We never talk about, you know, what happens. My favorite,
a lot of us do.
a lot of y'all do now,
Yeah.
but you didn't, right? When you were younger, you didn't. And so I think my favorite way anyone's ever explained it is a financial advisor, a friend of mine, and they had when they set up plans for their clients, they said that they planned like in retirement, they planned for the go-go years, the slow-go years, and the no-go years. And it's like, we all think about our retirement as the go-go years until you get there and you're like, oh, wait a minute, maybe I'm getting to the slow-go years, and now what happens? And so, you know, that's where I come in, is that I want to help you plan for the slow-go years and the no-go years. Because that's where the difficulties are going to be most acutely felt.
What are the steps if we are planning to come see you? Is there a form that we download first?
So not download. So what the steps are is you call my office and you get scheduled with my husband, Evan, who is my office manager. And he talks to you for 15 minutes and gets your basic information, gets your, you know, what you're coming in for, what you're doing. And then he gets your email address and your house address and all that good stuff. And then he sets you up on our portal and he sends you a questionnaire.
Okay.
And so then you can go in and do the questionnaire and schedule your appointment, and you'll get notifications of the appointment. And so then when you come in, I have all of your information that you've given to me. And then we sit down and we do our meeting. I have a very have a very handholdy approach. I don't believe in allowing people to sign documents that they don't understand. So I have a 3-meeting requirement. So you come in, you meet with me, we find out what you want, I draft the documents, and then you meet with me again to review them. And we go over them and you ask me your questions. If they're perfect and we can have a quick phone call where you're like, yes, everything is correct. I checked the phone numbers, I checked everything and we're all good, then I'm happy to do that too. I don't want to waste your time. But if you have questions over stuff, because part of my contract is you initial by something that says that you agree to read your documents. So you are agreeing to read your documents when I send them to you. If you have questions, you ask me. Right. And then I answer them and we tweak your documents however you need them to be tweaked so that you are comfortable with them. And then we schedule the signing after that. And so that's kind of how I work. Because I want to make sure that you know what you're signing. I don't want anyone to leave my office not understanding the documents they signed.
Thank you so much. I
You're
feel
welcome.
more comfortable already.
Well, I'm glad. Yes, 6575 West Loop South. My office suite is 145. I'm on the first floor. If you need to drop off documents, you can drop them off in suite 500 on the 5th floor. So like if you have previous wills you want me to review, if you have previous documents, I'll ask you to drop them off up there. And then I'll just go grab them from the receptionist up there.
Thank you so much for doing this.
Thank you.
It's really kind of you to share your expertise with us.
I am happy to do it. I am very happy to answer questions about this, because where else are you going to get the information? Because
the interwebs, which is completely unreliable.
And yes, the internet is not your friend when it comes to this stuff. So yeah, I'm happy to do it.
Thank you, Angela.
Thank you.
Really
Thank you.
wonderful.
Thank you.
My pleasure. Thank you all for having me. Y'all have a wonderful evening.